Making immigration law simple and streamlined for you, that's the NPZ Law Group, an international immigration law firm assisting individuals, families, and employers with US and Canadian immigration matters. Joining me is Ludka Zimovcak. She's managing attorney at NPZ Law. Welcome, Ludka.
Thank you, Vijaya. How are you doing today?
Doing well, Ludka, thank you. And a question for you, since Indian nationals need to wait forever to obtain that green card, what happens to the spouse and kids if the principal beneficiary happens to die while in the US?
Oh, that's a
sad question.
Yeah. Sad question, but you would be surprised. It happens quite often.
Oh, really?
Yeah, it does happen quite often. As you said, sometimes it takes 15 years and longer. But the key piece of information in your question was that the family members are in the US.
Yeah.
So that means this is a different type of protection compared to humanitarian reinstatement that we talked about many times. That's for families in India.
Mm-hmm.
So if they are in the United States, there is very broad protection for these surviving relatives under Section INA 204L. And this was only established in 2009, so we're very lucky to have it.
Yeah.
And it definitely helps all, the kids and spouse that survived, obviously.
Mm-hmm.
So it's much more expensive because who does it apply to? First of all, principal and derivative beneficiary of pending or approved I-130 petition, where the petitioner, who could be U.S. citizen or green card holder, dies. Mm-hmm. So with the traditional humanitarian reinstatement, the case had to be approved. But in these cases, under 204L, it could be pending. Also, derivative beneficiary of pending or approved I-140, which is employment-based petition, and that's where the long wait time is, where the principal beneficiary dies. Derivative beneficiary of a pending or approved I-130 petition where principal beneficiary died. Compared to humanitarian reinstatement, if the principal beneficiary dies, that's it. Derivative beneficiary has pretty much no rights. But also we have derivative of T or U visa if the principal dies. The same goes for asylee. Derivative, still would have these benefits, and also for WAWA, so derivative children would benefit. So it's it's much more expensive than normal humanitarian reinstatement. But what also is different? Well, obviously the key information here is that there has to be residence in the United States. So the applicant has to be, or one of the beneficiaries have to be living in the United States, residing in the United States at the time of the death, and continue to reside in the United States. That is very important. As far as the standard, how they make a decision, I would say if there is no issue, major inadmissibility issue, the case are generally approved because the government will only deny the petition if it would not be in public interest. So this is pretty fairly generous standard, very different than humanitarian reinstatement where we have to show, the medical conditions and so on. For family-based petition, we still need a substitute sponsor for affidavit of support. So it could be a green card holder or U.S. citizen who is at least 18 years old. And there has to be some type of relation to the applicant. So it's either spouse or sibling or a grandparent, legal guardian, just some type of relation. For I-140, that would not be needed. And, there is no particular form. So it's really just a letter. So it needs to be done in writing and informing them, that either petitioner died or a principal beneficiary. And it's really important to include the death certificate, proof of residence. That's crucial. So maybe a lease, utility bills, school records, just to show that, at the time of the death and going forward, that applicant is living in the United States. And, as far as the process, since there is no form, it just depends where the case is. So if the petition, whether I-140 or I-130, is already approved, and adjustment is just about to be filed, that can be done concurrently. So with adjustment of status, there could be a letter explaining who died. It's just really important to explain this is not the traditional humanitarian reinstatement, but it's under Section 204L. If the case is already pending, let's say adjustment has been pending for a long time, then obviously it goes to the same service center. It's just a letter with the supporting documents. And if the petition is still pending, it's going to go to that service center where the I-130 or I-140 petition is pending. So bottom line, very important to understand that it's different than traditional humanitarian reinstatement. Traditional humanitarian reinstatement could take years and years and years. This is a really nice protection, for, again, we have a lot of sad stories. So this is great. And this provision is also retroactive. So if this happened prior to 2009, somebody passed away, it's retroactive, so it could be used. So hopefully nobody has to use it, hopefully. But unfortunately, we do see a lot of these cases, so it's important for our listeners to know that, this type of section of law exists.
And thank you for bringing that. I didn't realize that it's more common than we would think, but that's obvious. I mean, life and death, who knows, but... I'm glad we covered that. So thank you so much, Ludka. Appreciate it. So folks, stay informed, stay prepared for all your US and Canadian immigration and nationality law issues. Reach out to the NPZ Law Group at visaserve.com or call them at 201-670-0006. And remember to mention Mirchi to get that special discount off your consult. So don't delay on getting your immigration matters sorted. Call the NPZ Law Group today. We'll be right back with more. Stay with us, please, on Mirchi. It's hot.